I have an admission, rather a confession. I am a hypocrite. I hope you feel that I'm bearing my soul at this point. I'm a hypocrite. Because I say to many of my PhD students who are going to present at conferences and to junior academics who seek advice on presentation, don't have too many slides. Keller, I've got loads of slides. So I'm going to actually rush through the first part, and you'll have to keep up with me, so just keep moving along, and because I want to spend a little bit more time on what I would regard as the more substantive part, because some of the early part is very introductory, and you all will be familiar with the literature and the comments that relate to it. First of all, I've got to give you a slide of our building. It's built into my contract, but I have to show you the law school at Leeds, voted number 5 most impressive law school in the world recently. And please write to my head of school and tell him that I've done that, and I might get some brownie points. No, I won't. No. Okay. Accountability of boards is a critical element to good corporate governance. That's accepted. That everyone sort of acknowledged that, and I've just referred to some academic commentary on that point. And it's been suggested that good corporate governance is basically based on achieving accountability of directors. Many countries have corporate governance codes, as we know. They play an integral role, so it is argued, in the corporate governance framework of that particular country. If that's the case, my view is that they should logically, therefore, provide a set of best practice as far as accountability of boards go. If boards accountability is critical, an important element, then code should address that in some important way. We've got many codes around the world. Kumo, Malin and Zattoni said in a recent paper that they had worked out there were 91 countries with codes around the world, and we know that they purport to provide best practice for companies in those jurisdictions. Now, the 3 types of codes, there are national codes, which we've been talking about, local rules or principles, if you like, and transnational codes. And it's on the transnational codes that I want to focus most of my time this morning. And I'm just checking on my watch. 50 minutes, wasn't it, Jill? Transnational codes or documents are not codes in the strict sense or the way that we generally talk about corporate governance codes, and we've discussed them in our sessions in this particular event. The objective of these transnational codes is basically to try and improve the corporate governance codes around the world, and to provide some sort of template is too strong a word, but some sort of basis or foundation for national codes, particularly those that are being developed in emerging economies. Now, the aim of my paper today, and of course the paper goes into far more detail than I can go into in the time allotted to me, but what my aim was to do was to analyse 3 transnational codes: the OECD code, the ICGN code, and the Commonwealth Corporate Governance Principles Code, and to ascertain the extent to which these make provision for board accountability. And it was on the basis that the way that they do provide for accountability, if they do that, then that may be regarded as a pattern for national codes in their construction in individual countries. And if they don't, maybe that's saying something about board accountability or saying something about the transnational code itself. Now, transnational codes have been said to be very important. There are a number of statements to this effect. We've seen a number of countries adopt parts of the OECD principles particularly, and I've mentioned some countries there, but notably China has relied a lot on the OECD principles in the construction of its own code in 2001. the adoption of the principles set out in these transnational codes has been very much relied upon by the World Bank and the IMF. They've basically said to jurisdictions, well, look, if you want funding, if you want finance, you want investment, then you're going to have to basically fit in with these codes and the direction that these codes take you. Of course, the transnational codes are not covering a territorial area. They are very broad. They're meant to be global in sort of operation, and they're intended to be of a general application, and therefore they can only obviously go so far, and I'm not suggesting that they can be prescriptive or completely all-encompassing, because that would not be possible. And they have to, of course, take into effect, well, they should take into effect, take into account, although I don't think they do, the fact that there are so many different approaches around the world in looking at corporate governance frameworks that are available. The tendency is one particular line, which I'll come back to if I have time later on. Just before I go on to that, just talk. Thank you. Look, at this stage, I need all the encouragement I can get. Accountability is an essential aspect of governance. We've sort of established that. And I mean, we could have a debate about that, but I'm sort of using it as a premise for today's particular address. So it's generally accepted that if you give power to somebody, then they've got to be accountable for that power. And really the reason for that is legitimisation. To be legitimate, like a government, you've basically got to be accountable. If you're not accountable, then it's argued that you're not legitimate. And the same goes for the boards of directors. And there are many publications of governments, of associations, of quasi-government bodies, of academics, those of us who talk about accountability as being critical, but no one really explains what does that mean and how does it fit into corporate governance. It's often said to be one of the pillars of corporate governance with transparency, but very rarely do you get someone addressing it. There's a dearth of literature on the subject. So I spent some time over the last 3 years looking at board accountability in some depth, and the conclusion of some of the work I've done and some of the work with Joan Lockery, one of my colleagues at Leeds, has been that we sort of constructed a 4-stage process of board accountability. And obviously I could talk about this for a long time. I'm not going to, because I want to use this as a jumping off point to say, well, this is what I see board accountability as being. And basically involves, first of all, disclosing and reporting, and I use that narrowly. Jill and I have had this discussion before. I use reporting and disclosing very narrowly, in the sense, these are some facts, and there they are. The second part is explaining and justifying, which some people like Jill would include in disclosure as an important part of disclosure. Thirdly, there's got to be an opportunity for questioning and evaluation of what the board has done and said it's done. And then finally, there's got to be the option of imposition of consequences. They may be negative, and often are, but they could be positive. So I reject the view that they always have to be negative. Many documents, as I said, have talked about the importance of accountability of boards. The Cadbury report, notably, we've talked about Cadbury a lot. Cadbury said that the reason we've been set up is, I use the word set up, I shouldn't say set up, I should say established, is the fact that we're here to deal with the fact that there hasn't been accountability of boards, because it was documented yesterday about those scandals like Polypec and Maxwell Communications led to, certainly the corporate cowboy approach in UK, and not just the UK, in many countries. I can always remember talking at Australasian Corporate Law Teachers Conference about the corporate cowboys in the early 90s. We had some absolute beauties, Alan Bond et al. So national codes can't really afford to ignore board accountability, it seems to me. And it's likely that codes that are established that in countries where there is a lacking in shareholder and stakeholder protection rights, there needs to be more rigorous board accountability to protect those particular parties. Now, the project that I set myself for this was to analyse these three transnational codes that I mentioned earlier, what is now the G20 OECD Principles of Corporate Governance, came into being in, I think, October of last year, which has been with us since 1999 in one form or another. The International Corporate Governance Network's Statement on Global Corporate Governance Principles, the last iteration was 2014, and the Commonwealth Association for Corporate Governance Principles for Corporate Governance in the Commonwealth, which goes back to 1999. Now, in my paper, I do actually discuss some of the principles within these codes, but of course I lack time, and I won't discuss them in any great detail. I've mentioned the fact that this is the 2015 OECD code. There's a lot of rhetoric being, well, some might say it's rhetoric surrounding it, how important it is, one of which came from the Secretary General. Well, he would say that, wouldn't he? But no one's really questioned the importance of OECD principles, and I'm not going to either in this particular presentation. The OECD, blimey, you're joking. What? You don't have a watch? How can you? Good grief. Moving along swiftly, very swiftly. Boom. Good grief. We're on to findings and assessment. So forget those slides. Good grief. I'm not coming to work for you anyway, I tell you. Good grief. You'd expect me to work at 6 o'clock in the morning with your watch. I'm there at 7 o'clock. You know. Okay. All of the transnational codes place a lot of emphasis on the board. They do that. And there are many similarities in content and approach. There are many commonalities one can find with respect to them. But what one doesn't find in any of these codes is an explanation of what accountability is. And probably that's intentional to a certain extent, because they want to leave it to the national codes to make some determinations. They don't want to obviously subvert the rights of national governments and associations to make provisions for their own particular needs. But the danger is, if it's not included in these transnational codes, it may send the wrong message that national code makers say, well, you know, we'll stick this in about accountability, but we won't say much more about it. And no one really knows what accountability actually involves. It seems to me there needs to be a greater steer, particularly for developing and emerging economies. So there's a lack of guidance, really, in relation to what accountability means. And national drafters, I know they can adopt or adapt or just ignore, but they're going to probably very often adopt large chunks of it because it looks good in the money markets and it looks good in impressing IMF and the World Bank. So there's a problem, it seems to me, that architects of national codes don't have a provision of guidance from these transnational codes. Another problem is the word accountability is used frequently in English, but it's not very easy to translate that into other languages, even cognate languages like French or German. It's not very easy to do that. And so it seems to me there's a need in these transactional codes to perhaps explain accountability more so that code makers can in fact grasp what is meant by this concept and then make provision in their own particular languages. I'll go over that because I haven't got much time. Sandeep will be having me off the stage in a minute. Thank you, mate. Great. Yeah. Right. Good on you, mate. Yeah. Okay. Also, we know that people have talked about passivity of shareholders. We talked about this a little bit yesterday, but people generally say shareholders tend to be very passive, and therefore they fail to engage with companies, and so we've got the stewardship code and things like that trying to encourage them to do that. And I'm not going to address that particular point, but that's often said to be the situation. It seems to me that if that's the case, then boards have got responsibility to be accountable, and codes should be addressing that issue, because obviously if shareholders are passive, then boards can sit back and say, well, we're not going to say anything because they'll do nothing about it at all, which of course is what we know has happened in the UK, that the fact that shareholders haven't done anything in the past when the codes have not been adhered to. Also, and this is a big issue that I've pushed for a while, and you can tell me, you probably will do, that I'm talking a load of rubbish here, but it seems to me that the fact is that codes, and I'm particularly focused on the UK code here, gives a great deal of discretion, unfettered discretion to boards, obviously to comply or explain. And in fact, they end up deciding what they're going to comply or explain. And that means that they can determine how accountable they're going to be, it seems to me. And that really does concern me, and is something that I think needs to be addressed in any particular national code if you're going to have one. And I must say, and I should have said at the beginning, this programme does not necessarily endorse codes. I'm trying to possibly look at what we've got and try to make some comments on it. The problem, as I've noted before, and has been noted on many occasions by others, that we're concerned that their explanations that are often made are boilerplated. You know, the classic one is, we're not complying because it's in the best interest of the company that we don't. What does that mean? Well, it can mean anything you'd like it to mean. And I say, one of the things that I'm concerned about is that with the transnational codes and national codes, is that accountability tends to be used glibly and cavalierly. Oh, well, we're talking about accountability. What do we mean by that? Well, you know what we mean by that. It's a gut reaction. Come on, get with the program. It's a gut reaction, and you basically know what we mean by accountability. Well, I'm not sure I do. But anyway, that's another issue. So, conclusion, we've got there, and I'll get some brownie points now, because I'm getting to the end. If there's a greater consideration of board accountability in transnational codes, then it's possible that national codes might address the issue more adequately in what they actually prepare. And I don't think national codes are absolved from not including this, but it's certainly, if transnational codes fail to perhaps give some sort of steer, then maybe we have to look at the transnational codes again. As far as accountability is concerned, the transactional codes really don't examine what it is. They say directors must be accountable, but whilst we do have some sort of flesh there, they say that they must do certain things, so therefore we assume that's accountability. It really doesn't deal with the gap that I can see that we have between what boards should be doing and then what they actually say they're doing. Everyone sort of seems to assume that everyone knows what accountability entails, but my argument is that I think codes should spell out accountability more for what boards are to be responsible for. I feel that given all of this, that this does not bode well for the life of codes. And what I think some governments might tend to do is say, well, look, we've got this code, therefore that talks about the boards being accountable, therefore we don't have to deal with it in legislation or in our case law or whatever. Therefore, it seems to me that it could mean that we end up with a failure to focus upon board accountability, which I say is important, and a failure in our codes to really address the issues that they should be addressing if we're going to have codes. And as I say, that's basically premised on the notion that we are going to have them, which I think is something which, of course, is a matter for debate, and we've had some we've had that to a certain degree already. I'm finished.
Thank you. Thank you very much. It's safe to say that you booked your ticket for the next forum because you complied with the time.
Or I'll explain why I didn't.
And you've done it with such good humour and good grace. So thank you very much for giving us the time.
Sandeep, could I start off with a question? Andrew, thank you very much. I know that you've been pressed for time. I mean, I think you cut about 5-6 slides there within 30 seconds. If accountability is a problem with codes, and I take your point 100%, it seems to me to be a big problem, because it's so core to any a code, and the board is so vital in ensuring good corporate governance. But suppose that we can bring more aspects of accountability into a code. Would that be more successful than doing exactly the same rather through hard law? Is it an evolutionary process that we start off and see, well, let's see how it's going to work if we put greater accountability and spell it out better in codes, and then go to legislation if it doesn't work? Or should we go to legislation immediately?
That's an absolutely, and I'm not brown-nosing, that's a really brilliant question. And I'm not sure I know the answer, because I think I need to really think about it for longer than a couple of seconds. But and I'm thinking out aloud here, so there's the disclaimer. I'm still suffering jet lag as well, and other things, but I won't go into those. I think that I start from the premise, and I think it's a fair premise, that the board should be accountable. And I don't know many people who would disagree with that. Well, I do actually. Probably Steve Bainbridge wouldn't agree with that, and there's a few others who probably wouldn't necessarily agree with that. But most people would say you've got to have some sort of accountability. It's then how do you have it? And that's really the nub of your question. I've got scepticism about codes and how effective they are. I remain to be convinced about the effectiveness of them and the enforceability issue. And I must admit, I come from well, in recent years from the UK background, with the fact that I've just not seen any evidence of an attempt to try and enforce it. And I mentioned rather, I suppose, flippantly the FSA earlier, the Financial Services Authority, but they did absolutely nothing. I could put it more strongly than that, but I won't put it like that. I think that if you're going to have a code, and we can say a code is something that could be effective, then yeah, maybe we try to have accountability in there. I do think, though, it's got to still be backed up with, I'm almost rather reticent about using the term now, hard law, but you know what I mean, statutory application. And we do have that. I mean, most countries do have a combination. For example, your own jurisdiction, my former jurisdiction, Australia's got that, in the sense that it does have a code, but it also has section 180, 181, dealing with the duties of directors, as many countries do. So there is provision for accountability there. So I think it's a matter of possibly having a mix of the two. But yeah, maybe what I'm saying is that at least we could explain a little bit more about what accountability is and what it actually entails. Oh.
Thank you. Just to really a follow-up question on that. If you go from the premise that yes, we go for codes, but we need more explanations with regards to accountability, so basically codes need to do more, what do you really have in mind there? Do you mean just the actual drafting has to be clearer, so it has to be redrafted, or is there anything specific that you maybe would like to or would be able to elaborate on?
Boy, another good question. This is tough. Where are the easy ones? No, it's a very good question. And I must confess that I've thought about this and not really come to any complete conclusion. What I do feel is that there'd be nothing. What you've got with the transnational codes, and very often with national codes, is a section dealing with directors. But they really don't deal with anything. They get to very general, specific things, like you've got to have a third of your board have got to be non-execs. Well, that's fine, But it seems to me that a code could do more than that by saying something a bit more in detail. And I would argue having something similar to the stages that I've developed for board accountability, and saying, making sure that saying that directors are to disclose the information that are mentioned in this code and in statutory legislation. They are to basically explain those particular disclosures, and then actually setting out the opportunity for questioning by shareholders, stakeholders, and then maybe an indication that there are consequences. Not setting out all the details, because that would be impossible, I accept. Now, some codes do actually say, for example, I think it's the International Corporate Governance Code, does say to the effect that the shareholders will be given the right to ask questions at an AGM. But that's really only as far as it goes. It doesn't say very much more about opportunities for question and evaluate what they're doing. So I suppose that to answer your question is, I think it's difficult, and I accept that, but I think that if you had in your section dealing with boards of directors, that you could actually have some higher principles, if you like, just setting out what really accountability does involve. And my argument was then that if you do that, then national code makers in countries could then say, okay, this is what they see accountability being, therefore we can then take that and maybe either duplicate their explanation of it, or at least put it into some sort of application. Okay?
Morning. This may be more of a comment than a question, but one of the things that I find really fascinating about what you're working at is that actually these codes are being drafted in the transnational domain, right? And what I was wondering is whether these codes take account of the fact that what is happening in the transnational domain is actually not geared towards corporations, but towards TNCs, which do not have TNCs, transnational corporations,
right,
which do not have an integrated or clear legal status. Because what you're describing is actually the sort of transplantation of codes through transnational codes that then get transplanted into different jurisdictions. And actually, I think that's part of the problematic of soft law. Sorry for re-invoking the word. is actually the absence of a transnational legal domain. And in that particular legal domain, or absence of legal domain, you get soft law application rather than a mandatory law. So the setup that you would have is that you would have a transnational level, and then all these national domains then implement sort of best practices of corporate governance codes. I was just wondering, I mean, if you look at TNCs, you have an unclear legal status of the entity itself, or the entities itself, but you also have stacking of board duties towards different legal entities within the group structure that take place within different jurisdictions and might actually conflict both in terms of the differences in board fiduciary duties and in the application of different jurisdictional systems, right? So I'm just wondering whether these codes actually speak to that particular problematic, and whether you would consider taking it on board for your article.
Yeah, I think a very good comment, very helpful. I think it's what I'm really saying is we've got these transnational codes. They purport to have an influence on national codes. You know, I'm sort of agnostic on that, but I'm saying if you are going to say that, then these transnational codes should have a good influence, I believe, and include those things that are important for national codes. So then we go to the point of you're talking about transnational companies, or the multinationals. I mean, obviously they are subject to certain requirements where they list and where their home is, or where they're registered. So they're certainly they're subject to some requirements in that respect. Is your concern that when they're operating in a jurisdiction which is not their home, how they're affected in that jurisdiction?
Well, I've got multiple concerns.
Well,
actually, I should probably refer the question to Beate at some point, because she recently had a whole symposium on this particular topic. But the status of transnational corporation. The transnational corporation does not have a legal status, right?
Yeah.
It's just a collection
Well-
of individual entities.
Well,
that
each
gives-
one does.
Well,
within
each
that
one
group.
does, but as
Yeah.
a group, it doesn't have an integrated status, right?
Well, corporate groups has always been a real problem. I mean, the European Union has been grappling with that in the insolvency field in recent times. And I think it's always been a problem, hasn't it? Because of the fact that, you know, you've got a group and it's made up of a number of different separate legal entities, and we all know the abuses that have occurred in that type of situation. You're concerned then about the accountability of the group.
Well, either the accountability of the group or conflicting accountabilities of
Yeah.
boards sitting
Within
on-
the group.
Within the group,
Yeah.
yes. And also
Yeah.
do these codes speak to that particular topic because they are transnational codes, right?
Yeah, they don't. I don't think
That was
so.
what I was.
Yeah, I don't think so. I think it's a very good point, and it's certainly something that I hadn't envisaged addressing. But yes, I think that's an interesting. The conflict. I like the. I say I like it. I think it's a very perceptive point. The conflicts that you may have between companies that could cause problems. But I think the short answer is no. That they don't address that issue. Maybe they should do. Of course, there is the code, the OECD code on multinational. Benali mentioned it yesterday, didn't you? No, but they don't talk about that either. Yeah, I mean, no code I found really deals with it. Yeah, please make it the last one. I'm being grilled here.
Isn't part of the problem that it's accountability is very much a moving target, and that during the time of Cadbury it might have been setting up an audit committee, and then subsequently telling people what its terms of reference were, what work had been done by the audit committee, then setting up a remuneration committee, a nomination committee, a risk committee, attendance. Now there's changes in view on who should be required to attend AGMs, this sort of thing. And certainly if you put things into hard law, then it becomes inflexible. But isn't there a general issue of the concept of accountability as being a moving target anyway?
I think the content of accountability is a moving target, but I would suggest that accountability as a concept isn't. So it's how you actually put flesh on the bones of accountability, and that will obviously, I think, differ between nations. So you've got, for example, the duties of directors put into legislation in many countries now. Finally, the UK has done it. But in some jurisdictions, you still don't have it, like the US. You don't have it in I'm right in saying that, aren't I, Kent? You don't have it in legislation, the duties? Duty of loyalty and duty of care is not in legislation. The duties of care and duties of loyalty are not in legislation in the States, are they? No, I'm right. I just didn't want to make a terrible faux pas. So I think that, yeah, the idea of accountability, I think, is something that doesn't change, but I think you're right that how you actually put flesh onto that, how you actually express that accountability in practice could change and that does develop. I suppose my concern over the things that you've mentioned about Cadbury, which led to the UK Corporate Governance Code, the combined code first of all, is that it sort of takes accountability as a premise basis, but doesn't explain what it is. I thought it would have been a brilliant opportunity for the Cadbury Committee to have done that, because they did say that the reason that they were set up was to deal with accountability of boards, and I thought that would have been a good starting point. But I don't wish to be too critical of it, because I think that certainly in the early days that made a big difference to UK corporate world.
I think we'll draw that to a close. Hopefully, Andrew has anything he's got to say on the topic.
No. I want more time.